rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We're here for oral argument in SKIPTON Holdings versus 9995-759 Enterprises, LLC, et al. Our case number CV23-0165. Counsel, I'd remind you that we are recording and live streaming the argument, so if you'll please identify yourselves and your client as you begin your arguments. Each of you will have 20 minutes. You're not obligated to use all your time, but appellate's counsel, you're responsible to watch the clock and reserve as much time as you wish for rebuttal. Also, please keep in mind we've read the briefs, we've studied the record, and we have discussed this case in conference. With that, counsel for appellant, you may proceed.
Thank you, Your Honor. May it please the court, Michael Poley on behalf of SKIPTON, I'll refer to them as SKIPTON just for shorthand, the plaintiff below and the appellant herein. The issues in this case, I would say the primary issues in this case, was it proper for the trial court to refuse to consider the extrinsic or parole evidence? And the related issue is, given the extrinsic or parole evidence, was it proper to enter a summary judgment in favor of, and I'm going to refer to them as enterprises, in favor of enterprises? The rules of interpretation are long-standing, and they exist not so much for well-drafted contracts. They're really more necessary for badly drafted contracts. And unfortunately, this contract, this easement agreement, would appear to be an example of a badly drafted contract. Courts are often called upon, as here, to interpret a contract that was drafted many years earlier, or even decades earlier. And in this case, it was decades. This easement agreement, it's part of the record, and it was drafted, it goes back to 1996. So, in any event, but ultimately, whether it's a contract that's 2 years old or 25 years old or 50 years old, the ultimate objective under the rules of interpretation is to attempt to ascertain what the intent of the parties was, the intent of the parties. In our view,
what's the starting point for that principle?
We believe the most governing case, the most relevant case, is the Taylor case from the Arizona Supreme Court, and that point, that idea that the penultimate objective is to ascertain the intent of the parties, is straight out of the Supreme Court's decision in Taylor. And
just to cut to the chase,
sure.
Question: what about more recent case law from our Supreme Court that says we turn to the plain language of the contract and we stop if there's no ambiguity in the contract?
I don't think that's currently the law in Arizona as I read the case law. Taylor if you look at Taylor, they start off by saying they look at different views. They look at what they call the restrictive view, okay? And that would be exactly what you just articulated, Judge Brown. The restrictive view would say, some judge, whoever the judge is, would look at it and say, is it apparently clear and unambiguous? That's it. That's the end of the equation. Don't go any further. That would be what Taylor referred to, the Supreme Court in Taylor referred to as the restrictive view. Then Taylor discussed what they call the Corbin view, which is, is there ambiguity? And if there's ambiguity, you look at parole evidence, and if there's no ambiguity, you ignore the parole evidence. But at least...
Let me quote you from Employers Mutual case, 2008 case from the Supreme Court. When the provisions of the contract are plain and unambiguous upon their face, they must be applied as written, and the court will not add something to the contract the parties have not put there.
I agree that that's the starting point. If something's plain and again, the ultimate underlying objective is what was the intent of the parties. If the contract's clear enough and is completely unambiguous, then that's fine. That's where you can stop. But under Corbin view and under the Taylor view, in reaching that conclusion, you would actually consider extraneous or extrinsic or parole evidence. I mean, let me just point out what the Supreme Court said in Taylor about the danger of taking the plain view of the contract too literally, because unfortunately you're going to sometimes lose the intent of the parties. I'll just quote, it's worth quoting because it's somewhat long. The judge, and this is head notes 11 and 12, the judge therefore must avoid the often irresistible temptation to automatically interpret contract language as he or she would understand the words. This natural tendency is sometimes disguised in the judge's ruling that contract language is unambiguous. Words, however, are seldom so clear that they apply themselves to the subject matter. On occasion, exposition of the evidence regarding the intention of the parties will illuminate plausible interpretations other than the one that is facially obvious to the judge. I think this directly approaches what you just asked, Judge Brown. And to continue with the quote, thus, ambiguity determined by the judge's view of clear meaning is a troublesome concept that often obstructs the court's proper and primary function in this area to enforce the meaning intended by the contracting parties. And then right after that, in head notes 13 and 14, recognizing these problems, we are hesitant to endorse, without explanation, the often repeated and usually oversimplified construct that ambiguity must exist before parole evidence is admissible. And they point out the most important reason for the reasoning and the rule that they adopted in Taylor, the Supreme Court. Finally, and most important, the ambiguity determination distracts the court from its primary objective, to enforce the contract as intended by the parties. Now, in Taylor, that was a tough case because there was a release that was entered into, and it very clearly and explicitly said it released all contract claims in return for the payment of a relatively nominal amount of money for uninsured motorist benefits. It was $15,000. Meanwhile, at the time, the party that was the releasor had a seven-figure bad faith claim. So again, that was not a clarity of drafting. It was not a good example of drafting by whoever prepared the contract.
Counsel, I apologize for interrupting, but just trying to sort of engage you a little bit at where I'm coming from on this. One of the problems I've experienced in people's overextensions of Taylor in trial courts in Arizona is that we're talking about Taylor as opposed to about the particular excluded evidence and whether the contract here is susceptible of the interpretation in the excluded evidence, which I think is really the point,
Agreed.
If you're the Taylor believer in this case. But Taylor doesn't give us license to say X means not X. And so it's sort of like this whole Taylor thing seems like a little bit of a distraction to me, because if you let something in, you say, okay, I'm going to ignore my sense that the language is completely unambiguous and means X. If you let in the thing that means not X, it still is not X. And at the end of the day, the jury can't reasonably conclude that X means not X. And so the question is, we can sort of tap dance around it analytically with this construct about ambiguity, but at the end of the day, does the excluded evidence here, is the contract reasonably susceptible of this diametrically opposed interpretation that the excluded declarant offered? Because Taylor doesn't help you if the answer is they're mutually contradictory. So please speak to that.
I agree with you. But I actually think we would win this appeal even if we took what Taylor refers to as the restrictive view. Because if you look at the easement agreement, it clearly sets forth certain easements, and the exterior bathrooms are not one of the explicit easements. But then it goes on, and this is the whole benefit burden idea, it goes on to impose a burden on the other parcel owners to help maintain the exterior bathrooms, and doesn't say anything about whether they have the right to use the exterior bathrooms. So it's not that, our position is not diametrically opposed to that easement agreement. If anything, even under the restrictive view, the easement agreement seems to beg the question. It raises the implication of, well, why are the other two parcel owners responsible for helping maintain the bathrooms if they don't have access to them?
So if you could just operationalize it, how does the excluded declaration that the court refused to consider, how is it consistent with the language that you would have it supply meaning to under Taylor? Just connect the dots for me.
I guess I'd phrase it a little bit differently. It's not inconsistent with the language in the easement agreement. The easement agreement is ambiguous. I think even under the most restrictive view, the easement agreement is ambiguous. It doesn't say only, in other words, if the easement agreement said the bathrooms belong solely to the enterprise's parcel and no one else shall have any right to use them. If it said such a thing, then you're right. No amount of extrinsic evidence could overcome that, I don't think. But it doesn't say that. It just is silent. It imposes a burden on the other two parcel owners to help maintain the exterior bathrooms without saying one way or the other, whether they can use them. And I'd like to point out here, the extrinsic evidence, so under Taylor, and as you point out, Judge Jacobs, it adopts what it calls the reasonably susceptible standard. As I read Taylor and I read the restatement, that seems to be a more relaxed standard than even the Corbin view. But in any event, so you look at the extraneous evidence here, the extrinsic evidence, and is our position, is the language reasonably susceptible to our position? I think we have an enormous amount of pro or extrinsic evidence here. We've got, best of all.
Which is the best?
Oh, clearly. It's a declaration of the guy who helped draft the contract.
How so?
Well, he comes right out and says, I'm looking at Larry Kobe.
But isn't it wishful thinking? He says, this is what we intended, this is the way we should have drafted it, but we didn't.
But again,
I have the same question as Judge Brown.
Again, the ultimate objective is what did they intend? Okay, and let me just point out, we got a wealth of extrinsic evidence. They don't have any contrary evidence. They have a contrary argument. The contrary argument that they
The contract language is some contrary evidence, counsel, right?
Yeah, that would be some, I'd agree. But they don't have like other extrinsic evidence. They don't have some other drafter saying, hey, Mr. Colvin's completely, out of it. That's not what we intended. That would be extrinsic contrary evidence. They don't have anything like that. So you asked what's the most strongest evidence, Judge Brown? I think the Colvin Declaration is far and away the strongest evidence because he says, I was involved in the drafting of the easement agreement. Okay, that's uncontested. And remember, this was a summary judgment ruling, right or wrong. It was a summary judgment ruling. And then he also goes on to say what was intended. So I think that's the strongest extrinsic evidence.
So how does this work? In Arizona law, we have this exclusio unius canon that if you leave it out, we think you meant to leave it out. But somehow when someone says, I didn't put it in there essentially, but I really subjectively wanted it to be there, we don't draw the inference that it was intentionally excluded? Why would that be?
The point is there are a plethora of interpretive tools. But ultimately, I go back to what Taylor said. The ultimate objective with any of these interpretive tools, what do they intend? That's all we're trying to figure out, and it's very difficult for judges, particularly 25 years down the line.
What did the contract language mean they intended? We're interpreting the language that your declarant caused to exist. We don't want to interpret his subjective unexpressed intent for the sake of it. We're interpreting the intent as embodied in the writing, correct?
I think I'd vary that a little bit. Clearly, we have a writing, and we have to deal with the writing, and that's meant to be an expression of the party's intent. But as Taylor pointed out, sometimes what is an apparent, unambiguous expression of the party's intent in a document isn't really what the party's intended, and that's the whole point of pro or extrinsic evidence.
But that's because you're using the extrinsic evidence to reinterpret the language of the contract. It's not that we have an independent concern about their subjective unexpressed intent. That's different.
I would respectfully submit we're not reinterpreting it. We're adding context to it that otherwise wouldn't exist but for the pro evidence. Because it's not just the Colvin Declaration. You also have a 25-year course of conduct. And we cited, I forget the name of the case now, but we cited in our reply brief that it's really strong to look at course of conduct.
But it's like John Marshall. Never forget it's a constitution we are expounding. We're interpreting a contract, albeit sometimes using extrinsic evidence for the reasons you're explaining. We're not interpreting their intent as a freestanding thing. We're interpreting the contract, and the intent is a way of, the verbal expressions of intent are a way of supplying meaning to the contract that we interpret, right?
I agree with you.
Okay.
The point, though, is, let me put it this way. Let's say that there was no summary judgment entered. Let me just point out, the reasonably susceptible question under Taylor is clearly a question of law for the court in the first instance. If the court reaches the conclusion that our position, in this case, our interpretation of the contract is reasonably susceptible of being supported by the extrinsic evidence, then it goes to a jury if there's contrary evidence. I don't actually think there's contrary evidence here. If you agree with our legal reasoning, we believe the relief that should be granted is to remand with instructions to enter the summary judgment for us. But if not, at a minimum, it should go to a jury. Now, imagine this case in front of a typical jury. You've got a course of conduct for 25 years. You got one of the drafters coming in and testifying, well, this is what we intended. You got an integrated project. That catwalk on the second floor, The only reason it exists is so those other two parcels can get access to the exterior bathrooms. You've got integrated project in the sense that the SKIPTON project parcel has the only electrical for the project, it has the sewer for the project, it has the fire suppression for the project. And you got the case law that says you don't want to reach an absurd result. You got, I mean, which is another way of saying you got common sense that plays into this, okay? I mean, you know, compared to like the Taylor case where they found a question of fact based on a pretty thin record of extrinsic evidence. I mean, there wasn't that much. I mean, they had a little bit of, they had common sense. They basically said that the carrier didn't, the document from the carriers, they didn't intend, they said that 15,000 was for the UM claim. And common sense was, why would you take 15,000 for a 7-figure bad faith claim? I would suggest we've got a lot more pro or extrinsic evidence in this case. I think we have an enormous amount, and they've got a contrary argument, which is ignore it, but they don't have any contrary evidence. Okay, so,
Counsel, I have a question about, so you seem to be saying, you know, the contract says, you know, we're responsible for helping to maintain the restrooms, and so you're saying, how could we bear this responsibility if we're unable to access them? Have you borne any responsibility? Have you contributed to the maintenance or upkeep of the restrooms?
Yeah, no, they, before the Hepburns bought the property through their enterprises entity, there was never a problem through a number of different owners, and they always contributed to the cost of maintaining the bathrooms, and they always had access to the bathrooms. So it all, I mean, we have a 25-year course of conduct that changed when Mr. and Mrs. Hepburn bought the property through their enterprises entity. So I think that's part of it. I mean, the burden and benefit idea, I think that supports us, but I think that's, you know, small, that's a lesser critical issue than the Coben Declaration as to what the original intent was by one of the drafters, the 25-year course of conduct, and I really think the integrated nature of this project is really a powerful factor. I mean, you've got 3 parcels with each have 1 interior bathroom. The SKIPTON parcel is twice as large as the others, and you've got 4 exterior bathrooms with a catwalk so the other 2 parcels can get access to it, and you've got critical shared infrastructure in the SKIPTON parcel.
So
Yes, Judge.
is the layout the same as it was when back in?
Yeah, it's never changed.
Never changed. What about ownership of the lots? Wasn't it one parcel at one point, and then it was divided?
Yeah, well, it looks like they came up with this idea before they built. That's what the record indicates. They came up with this idea of this integrated project with 3 different parcels. They did that before they built it, and then they built their parcels. That's what the record, as I saw it, indicates. But, you know, I just think we've got a pretty powerful constellation of extrinsic or pro evidence here. I mean, what I started to say is, imagine if you put all this extrinsic evidence in front of a typical jury, it would be shocking if that jury rules for enterprises in a typical situation. Now, then, that jury's not burdened with like all the legal concepts that we all have taught and learned since law school, like pro evidence and ambiguity and, you know, that kind of thing. If a jury, just from a common sense point of view, looked at it, they're going to rule almost invariably, 9 times out of 10, or perhaps more often, they would rule for SKIPTON in this situation. That just shows the power of the extrinsic evidence. I'm down to a few minutes, but I'd like to answer any questions that you have, additional questions, or otherwise I might reserve what I got left for rebuttal. Thank you, Your Honors.
Thank you. Counsel?
Good morning, Your Honors. Michael Harris on behalf of the Appellees, the Enterprises Parties. Your Honors, everybody agrees here that the easement agreement is the contract that governs, and there's been a lot of talk about what evidence we're relying on. That's the evidence we're relying on. We're relying on the contract, the 4 corners of the document. So I want to start with the plain language of the contract, which I think Arizona law requires to be the starting point. And the contract itself states the intent of the agreement, and that was to, 1, coordinate the location of all utility lines and the grading and drainage for the parcels, and 2, to create certain reciprocal easements and rights in and to all vehicular entrances, exits, driveways, and parking areas. Now, there's been some discussion about the utility lines, such as the electric, fire suppression, and sewage, and that's inherent in the motion for leave as well. It's our position that that's related to that stated intent for the utility lines, but I'll get to that later. As to the easements, The easement agreement is not ambiguous as to which easements are provided for. It's set out in paragraph 1, subparts A through E, and consistent with that stated intent, it includes easements for parking, landscaping, things of that nature. Because this is now one unified parcel, people need to get across the parking lot to get to their respective buildings. So that's the intent of the agreement, and that's what we're relying upon. Now, the SKIPTON parties, on the other hand, are asking the court to extrapolate a single reference to exterior bathrooms in the shared expenses section to create a perpetual easement. Now, that's not proper under Arizona law, and there's nothing in the contract to provide for a perpetual easement. Importantly, there's also nothing in the easement agreement that requires enterprises to keep the bathrooms open or prevents them from closing them, converting them to interior use, and that's exactly what they were asking the trial court to do, to rule that they were allowed to convert them to interior use or otherwise close them.
Well, let's break this down to common sense here a little bit. What's the purpose of that clause 8B, and why the references to outside window cleaning, exterior bathrooms, painting, and other activities? What's the purpose? And especially the exterior bathrooms, because let me follow it up with, there's the principle of contract law, of course, just like in statutory interpretation, that we strive to avoid having any term of the contract be superfluous. It doesn't have meaning. So explain to me, what is the meaning of this paragraph?
Certainly.
Without even tying it to the easements. I'm not saying it's tied to the easements, but what's the purpose of it?
And I don't think the majority of it is tied to the easements. So generally speaking, I think the purpose of the paragraph is to address just some shared costs for these three owners. So painting of the buildings, outside window cleaning, they've agreed to share in those costs.
But not the bathrooms.
No, as to the bathrooms, it does say they're required to share in the cost of exterior bathrooms. So it's our position that if there are exterior bathrooms on the property that are open for everyone's use, they're required to share in the cost of those bathrooms. If there are not, then there are no costs to share. Now, and I understand why Your Honor is asking about that. Obviously, it's curious that they're required to share in those costs, but I don't think it creates a conflict in the contract. And I certainly don't think that it creates an obligation then for my clients to keep those bathrooms open in perpetuity or to otherwise prevent them from closing the bathrooms. If there are no exterior bathrooms on the property, then certainly there are no costs to share. Now, there was also some discussion of whether the SKIPTONs have previously paid for maintenance costs and the other owner as well, and that's true. In the past, it's not disputed that these bathrooms were open. The prior owners gave people permission to use the bathrooms. They shared the costs. My clients came in. They said, well, we're not obligated under the contract to do that. We're going to close them. And of course, at that point, they no longer asked for the other owners to contribute to the costs because they weren't open to those owners' use. So that's, I think, Your Honor, what paragraph 8B means as far as the larger project here.
So I think what you just said is that his discussion of the prior course of conduct that he says would make this a slam dunk win in front of a jury for him begs the ultimate question, which is that course of conduct doesn't require you to maintain it in perpetuity. It just means they have to pay if it's open. It doesn't mean you have to keep it open, which is the whole question under the contract you're here to discuss.
That's absolutely right. So I don't find the course of dealing or course of conduct nearly as persuasive as my colleagues. It's not disputed that these bathrooms were previously open for use and the prior owner gave permission. Now, supporting that course of conduct, they've submitted 4 declarations, 3 of which I think are entirely irrelevant, is just saying what we already know. They're from non-owners. It just says, yes, the prior owner gave us permission to use the bathrooms. It does not opine at all as to the meaning of the easement agreement.
To talk about the declarations, and I'd like to try to get you to meet as squarely as we can your colleague's argument, you kind of rephrased the operative inquiry at the start of your argument as about ambiguity, which is how abstractly some people would like the law to be. But, you know, he's right about Taylor and the reasonably susceptible language. Can you use that reasonably susceptible language and answer the question I asked him? For the excluded declaration, why, in your view, I'll ask you the opposite, is the contract not reasonably susceptible of the interpretation that is latent in the excluded declaration? Please express reference to them and answer that for me.
Sure. So here, this isn't a case of a contract where it suggests there are certain easements and that we're not sure what they are, so we need to go figure out with parole evidence what they are. Here we've got a paragraph 1 with 5 subparts that sets out all of the easements very explicitly. We know exactly what those easements are. We know what the terms are. We know how they apply. There's just nothing to suggest there is no easement to the bathrooms. It doesn't exist. So what my colleagues are saying is that the contract is reasonably susceptible to their interpretation solely because there is a cost-sharing provision in there. Now,
But what about the declaration? He's saying the excluded declaration, the contract is reasonably susceptible of the meaning that is set forth in the declaration. Can you bring those two concepts together? The excluded declaration, what it says, and why the contract is not reasonably susceptible under Taylor of the meaning it suggests. That's what I didn't really get an answer. I'd like an answer to that.
sure. And are you referring to all 4 declarations or specifically the Coben declaration?
Let's start with Coben.
Sure. So Coben, obviously one of the drafters. I think Your Honors put it well. I think Mr. Coben's declaration is frankly wishful thinking. There is no easement to the bathroom. Now he can say it was his intent to create an easement to the bathroom 26 years later. The fact of the matter is he didn't do it. And I think Judge Fox at the trial court level put it well when he asked if it was really Mr. Coben's intent to create an easement to the bathroom, why didn't he include it? They obviously, that's the easement agreement is titled an easement agreement. It's got an entire paragraph devoted to the easements, and this isn't a question. Go ahead.
See, but this is the thing that's really troubling for me about both sides of this argument, frankly, trouble me. Because if the best answer we have as to why it's not reasonably susceptible is, well, it's not in there, well, then we're just back to interpreting plain language, which is, a terrain that's better for you to play this one on than where they want it. But he's right. Taylor leads us to the concept, is the contract reasonably susceptible, which means you're probably talking about evidence of things that aren't quite expressly stated. So can you help me understand why, from your point of view, other than the fact that it's not there in plain language, why this easement agreement is not reasonably susceptible of what Coben is saying was meant?
I can. So, I think it would be a closer call and would be more reasonably susceptible if, for example, paragraph 1 didn't exist and there were no easements delineated. Because they've chosen to delineate those easements, now we know, okay, they were thinking about easements, they wanted to delineate certain easements, they've done so. They chose not to include the restrooms.
So there's a conscious design to exclude, like my question about the exclusio unius canon. It's like that.
Exactly.
Okay.
That's correct.
Sorry, thanks.
Now, as far as course of dealing, I know there's a lot of weight being given to that by my colleagues. Again, I think all of the cases on that matter are distinguishable. I think the course of dealing here related to permissive use. I'll address, I've addressed AROC in my response. Associated Students has been addressed in my answering brief at length, as did the trial court. I'll just briefly address the Anderson and Preferred Stock Food Markets case, which was raised in the reply I didn't have a chance to address. And in that case, that was a litigation to enforce a personal guarantee in connection with an investment. And the court allowed parole evidence to show that that guarantee was conditioned upon a prior condition precedent. So the decision turned on whether the parties had an oral agreement as to that condition precedent. Now, again, that's not what happened here. The parties are not litigating whether the easement agreement was conditional, whether it's enforceable. The parties are just litigating over whether that easement exists or does not exist. So I don't think the Anderson agreement applies here. I'd like to, unless there are any other questions on the easement agreement, address the accounting and motion for leave. So moving just to the accounting issue, as an initial matter, I think it's questionable whether that claim was even brought. If we looked at the First Amendment complaint, there really isn't a claim as to an accounting, although there's a passing reference to it in the general allegations. But even if there was, here we've got a motion for summary judgment that was brought on that issue, cross motions in fact. The trial court heard argument on those motions. Counsel for the SKIPTON simply chose not to address that issue at oral argument. And the trial court granted the motion in favor of my client against their client, entered a final judgment pursuant to Rule 54C. At no point prior to this appeal did the Skipton parties try to alert the judge, hey, we had this accounting issue, we didn't see that you addressed it, can you either clarify your ruling or reconsider it? Instead, they simply allowed a final judgment to be entered. So frankly, I think that issue was waived. Even if it wasn't, there's simply no requirement in this contract that my clients submit an accounting to the Skipton parties. That does not exist. And if assuming they brought a claim, that claim would be based on a failure of my clients to provide that accounting. There's no requirement that my clients provide them with accounting. Even if there was such a requirement, my clients did provide them with an accounting. They provided them with invoices. They showed the expenses they paid. Each of these three owners have agreed, okay, you're going to be responsible for this. My clients were paying the electrical bills, among other things. So they provided those invoices. So the granting of a motion for summary judgment in my client's favor on that issue was both procedurally proper and proper on the merits. And finally, as to the denial of the motion for leave, now the Skipton parties have characterized this as just a simple amendment or clarification of the court's ruling related to the exterior bathrooms. And what they're seeking to do is, quote-unquote, extend that ruling to certain electrical components, sewer pipes, fire suppression equipment, and my client's USPS mailbox. So, in other words, in plain language, what they're trying to do is cut off my client's electricity, sewage, fire suppression systems, and remove their access to the mailbox. Now, these are entirely new facts that were never addressed until the motion for summary judgment was granted after 2 years of litigation. And frankly, the trial court ruling, which was very narrowly tailored to whether an easement to the bathrooms existed, had nothing to do with those other issues. And in Arizona, denial is proper if a court finds either undue delay, bad faith or dilatory motive, undue prejudice, or futility. And the Arizona Supreme Court found that notice and prejudice are critical factors. Now here, it's our view and the trial court's view that the timing clearly demonstrated undue delay. Now on page 44 of my answering brief, I've put the full timeline. I won't go through that all here. Just suffice it to say that the case was filed on October 9, 2020. After that, we've got about 2 years of discovery, negotiations. Ultimately, our MSJ was granted on December 6th, 2022, over 2 years later. And the motion for leave wasn't filed until about a week or two after that. So in other words, the Skipton parties lost the case in its entirety and then elected to file a motion for leave to try and cut off my client's essential utilities. So clearly the timing, I think, demonstrates undue delay, but it also demonstrates dilatory motive. My clients prevail on the case in its entirety. The Skipton parties appear to be seeking retribution and trying to cut them off from essential utilities. If there really was a genuine dispute as to these issues, it should have been raised at the time either the complaint was filed or a first amended complaint, and then we could have had a discussion as to whether these essential utilities fell under the intent of the easement agreement, which stated it was to coordinate utilities. But we didn't have that opportunity, and there's certainly not a basis now, 2 years later after the case is over, to reset the case in its entirety and to go back. Now, the Skipton parties have cited 2 cases, which, again, are both distinguishable. I'll address briefly. The first is Walton v. Hager. In that case, a plaintiff originally pled an express contract claim, permitted to proceed with quantum merit, essentially a related claim. That's not at all what happened here. Keystone Copper v. Miller, a party was permitted to amend offenses and add a defense of estoppel at the time of trial. Again, not at all what happened here. This isn't simply, as they're claiming, a desire to conform new legal theories to the facts. This is adding entirely new facts, which we've never discussed. There's never been any discovery related to these other utility issues. We haven't discussed them at all until after the motion for summary judgment was decided. So in short, the motion for leave was properly denied, And just want to point out again, that's an abuse of discretion standard rather than the de novo. And unless your honors have any further questions, I have nothing further. Thank you.
I found the case that we cited in the reply brief that talks about the course of conduct. It's the Abrams case. It was on page 17 of our reply brief. Quote, when an agreement involves repeated occasions for performance by either party with knowledge of the nature of the performance and opportunity for objection to it by the other, any course of performance accepted or acquiesced in without objection is given great weight in the interpretation of the agreement, Abrams v. Horizon Corp., and we cited other cases of the same concept.
But his point in the colloquy we had about your prior argument was that the course of conduct simply establishes that if the restroom is operating, then there is payment for it. How does that bootstrap you into the legal principle that it was meant that you had an easement to it? How does that work?
If that's all we had, it would be harder. It would be harder to reach that conclusion. But we also have the declaration of one of the principal drafters. And and there was reference to Judge Fox saying, well, how come you didn't say there was access to the bathrooms? Well, the point is, people screw up when they draft contracts. As I said at the beginning of my argument, we don't need these interpretive rules if everyone does everything explicitly right and they draft a really good contract. We need them for when people mess up. And unfortunately, human beings, the nature of human beings is we mess up. At least as a general rule. I hope I don't, maybe I do. But the point is, we need these contract interpretive ideas and rules because people don't always draft contracts the way they should. And no one's going to say that this contract, this easement agreement, is a model of clarity. Okay? In fact, when you look at the provision that talks about, sharing the expenses for all these things, it refers to a paragraph that doesn't exist. Let me get it in front of it. It doesn't really matter, but here it is. It says, notwithstanding Section 7A, there is no 7A. Okay? I mean, whoever drafted this probably should be embarrassed by, I don't know whether it was a lawyer, it may not even have been a lawyer. It may have been real estate guys. They love drafting contracts even though they never went to law school. So anyway, I guess I'll briefly mention.
But counsel, it is difficult to ignore the fact that certain easements were expressly declared in the contract,
Sure.
and this one wasn't.
I agree. And and my colleague admits that his case rises or falls on that exact idea. The four corners of the contract grant certain easements and do not grant an easement for the bathrooms explicitly. They do not grant, by the way, they also don't say in any way, shape, or form that the electrical, the fire suppression, and the sewer that's located on the SKIPTON property, that they have some sort of access and use of that in perpetuity. They don't say that either, which feeds into the whole motion to amend. I mean, we didn't ask for that in the original complaint. That's not our preferred objective. Our preferred objective all along was to take the 25-year course of conduct and what Coben says was the original intent and continue it. But the motion to amend boils down to the goose-gander idea, and I'm running out of time. What's good for the goose is good for the gander. Thank you, Your Honors.
Counsel, thank you both for your arguments this morning. This matter is under advisement, and we'll issue a decision in due course. The court stands in recess to set up for the next argument. Thank you.